Thank you very much, Professor Family. We'll now begin questioning, and I'd like to start, Mr. Rifkin. The federal court didn't pull any punches in concluding that the administration's executive amnesty was in direct violation of federal law. Indeed, the federal court noted, quote, "The very statutes under which defendants claim discretionary authority actually compel the opposite result." The federal court further noted, quote, "The DHS secretary is not just rewriting the laws, he is creating them from scratch." That is a direct conclusion of the federal court in this litigation. Mr. Rifkin, the question I want to ask you is twofold. Number one, do you agree with that assessment? And number two, if you do, what are the consequences for the rule of law if the executive has the authority under the guise of prosecutorial discretion to categorically refuse to enforce this federal law and other federal laws?
Chairman Cruz, as to the first question, having read very carefully Judge Hannon's decision, I think he's absolutely right. This is indeed rewriting of a law, and to make one point, it was not done in a subterranean fashion. It was done in the daylight. The President not only had the Secretary of DHS issue this, not a policy statement, but a pretty binding opinion, but a number of statements issued by the administration indicated clearly what is going to happen. So the notion that there's going to be a meaningful exercise at the field director office is well, to put it gently, is risible. And we also have a little bit of experience with a predecessor of DAPA called DACA, where out of hundreds of thousands of applicants, less than 3%, Mr. Chairman, were rejected. To me, that pretty clearly demonstrates that this is a wholesale dispensation of the law relative to a particular category of individuals, which is, of course, utterly unconstitutional and violates the President's faithful execution duty. As to what this would portend, let me also briefly link the APA arguments that I think are very important here. We have an administration that's really done three things, and I pointed out in my written statement. It has first rewritten the law. It is then did not bestir itself to comply with, let's call them structuring statutes, like APA, because the whole purpose of APA, for respect, and Article 1 delegates some authority to Article 2, which the courts have upheld since the New Deal. It wants to cabin, to discipline that exercise by having statutes like APA that provide for a structured approach to decision-making, notice, comment, judicial review. Oh, and the third thing, they said nobody has judicial review. So where the administration that wants to rewrite the laws, not comply with any structuring statutes that cabin how the executive does it, even then it is given authority, and then there's no judicial review. That decision stands. It warps separation of powers, which is the primary means of protecting individual liberty. And for those who care about policy results, which I have nothing to say since I don't think it's relevant to the law, let me tell you, if that endures, if this is the new constitutional baseline, future presidents would suspend on their own and rewrite tax laws, worker safety laws, pharmaceutical safety laws, and various other things that are very, very important in an administrative state. So it is a horrible situation.
Thank you, Mr. Rifkin. I'd like to shift now to you, Secretary Kobach. The federal court in Texas heard evidence and that if the President's amnesty program went into effect, that just in the state of Texas, it would apply to at least 500,000 people who were here illegally. And that, as a consequence, when you add up the personnel costs, the facilities costs, the cost of driver's license production, and all of the other costs, the 2-year price tag to the taxpayers of the citizens of Texas for the President's illegal amnesty was in excess of $103 million. That was included in exhibit number 24 in the trial, and without objection, I'd like to enter that into the record of this hearing. My question to you, Secretary Kobach, does your home state of Kansas and do other states face similar costs if some 4.5 million people here illegally are granted amnesty, issued work authorizations, issued driver's licenses contrary to current law?
Yes, we do face similar costs, and one of the reasons we can't give you an exact number is because the federal government, the Obama administration, will not give us the exact names and dates of birth of the amnesty recipients. If we had those names, we could then see if these individuals are receiving these benefits, these X number of people have received a driver's license. So instead, we have to estimate. But if you do estimate in Kansas, for example, the number of people who've received the DACA benefit is much smaller than in Texas. Of course, our state has fewer illegal aliens, but it's roughly 6,000 at this point, using the federal government's numbers of people in the state. Assuming 2/3 of them get a driver's license, you're roughly talking about, and again, assuming agency cost is conservatively about $150 a driver's license, you're talking about $600,000 on driver's licenses alone. But then if you add all of the other services and benefits that the person can avail himself of, once he has that deferred action, then the price looks much larger. I would say approximately $38 million. Again, you have to assume, we don't know the names of the DACA recipients. But then if you add to DACA another 35,000 approximately Kansans who would be available for DAPA, then you increase all of those numbers roughly sixfold. So you're talking about a whopping increase over what was already an illegal and expensive amnesty.
And does that have a consequence for voting in the state of Kansas if people here illegally are given driver's licenses?
Interestingly, it does. The driver's license and the Social Security number are documents that the National Voter Registration Act specifies as documents you can use to register to vote. So, for example, my fellow Secretary of State in Ohio wrote a letter to the President asking for what I just mentioned, a list of names and dates of birth so he could check the voter rolls and see if these individuals had not been registered when they go to get a driver's license, because many driver's license clerks will, after asking hundreds of people each day at the end of the interview, would you like to register to vote? They'll ask the same question, and people accidentally get on the voter rolls this way. The administration has refused to provide that information. In Kansas, we are more secure against that because we are one of 4 states that requires proof of citizenship at the time a person registers to vote. The other 46 states, however, I would wager that a significant percentage of these individuals, once they get the driver's license, are probably becoming registered, whether willfully or unintentionally.
Thank you, Mr. Secretary. Senator Coons.
Thank you, Chairman.